Hello, this is Jennifer Smith. Welcome to Franczek Radelet monthly webinar this month, where we'll be speaking about obligations regarding DCFS and ANCRA. So that's obligations to report child abuse and neglect. This month, I'm joined by Kendra Yoch, one of my partners here at Franczek, who specializes in working particularly on student issues. So this is right in her wheelhouse, and I'm very happy to have Kendra join us this month. We're going to start with really a cautionary tale, a video clip. In just one second here. Here we go.
Police say the principal and the math teacher knew about the allegations, but they didn't do anything. Perry Upper Elementary School Principal Kendra Miller and teacher Jeff Sullins are accused of failing to report child abuse and neglect to authorities. According to court documents, for weeks, students had told them that teacher's aide Arnold Cohen was touching them inappropriately. The principal and teachers said they didn't tell police because they didn't believe the students' accusations. But according to court documents, Cohen admitted to authorities that he had inappropriately touched the students for what may have been up to a year.
I send my kids up here to be taken care of, not to have something like this going on. I think that they should be reprimanded or something, because it's not right. If you knew about it, don't just assume the kid's lying, because most of the time they are not.
Both Miller and Sullins were booked and released. They will appear in court at a later date. In Perry, Crystal Price, KOCO 5 News.
So again, that's a cautionary tale of what we never want to happen to our clients. So to avoid that and to help, today we're going to answer frequently asked questions. And we have questions prepared, but in addition, all participants can enter questions on the left part of your screen, and we'll be happy to field as many questions as we can fit in and look forward to that interaction. To get us started, though, I'll turn it over to Kendra.
Okay, good morning. So we'll start with the first question is, when are employees required to take mandated reporter training? And obviously reporter training can help you avoid disaster like the one that we just saw. Starting with who is actually a mandated reporter, it's all school personnel and all personnel of institutions of higher education. So it's really broad, it's gonna encompass everybody. With respect to training, you might be surprised to hear that you don't have to complete the training until within 1 year of when you begin employment, and then every 5 years thereafter. We certainly do recommend that people get that training earlier in their employment to help avoid problems down the road. In addition to that training, prior to starting working, mandated reporters do need to sign a statement that they have knowledge and understand the reporting requirements. So that's one of those, as soon as you have somebody hired, they need to sign that before they start working, so they are aware that they are a mandated reporter and what the responsibilities are related to that.
Great. So with that, our next frequently asked question is, what if I am not sure abuse or neglect occurred? And this, we do get questions from our clients quite often. Here's the scenario, what should we do? Should we call DCFS? And first I'll start with the legal obligation, which is to report when there's reasonable cause to believe a child may be abused or neglected. And the way that I define that reasonable cause is really, if you can call me and explain why you're calling, that you think there might be abuse and neglect, I usually say, make the call. That's a reasonable cause. You don't need to have any certainty that it happened. It doesn't need to be more certain, more likely than not that it happened. It's just some reasonable cause to believe that it happened. So when in doubt, do report. I guess I will say sometimes in holistically helping families, the concern is once we report to DCFS, we're going to have broken the relationship with the family. They're not going to be as willing to work with us. And that is true. I mean, I'll say that is a real and realistic concern of reporting. But if you do have that cause, you don't really have a choice. At that point, you need to report. But that I just want to acknowledge that in working with families, this can be complicated, and I understand the reasons why sometimes you hesitate. We will say we saw one startling fact from DCFS is that a child tells an average of 7 adults that they are being abused or neglected before a report is made. So, you know, at least based on the information DCFS has, there are adults out there with this knowledge, and it is something that needs to be reported. With that, I'll turn it back to Kendra.
Okay. Question 3, what are the signs of abuse and neglect? So there are really kind of 3 categories here. One is physical abuse, the second is sexual abuse, and then finally neglect. And so with physical abuse, I think that's the, maybe most common thing that people think of. It includes physical injuries, excessive corporal punishment, as well as providing children access to controlled substances or exposing the child to the manufacture of methamphetamine. Signs of this are going to be unexplained injuries. Additionally, you might see a student who is fearful of going home or with a particular caregiver, difficulty doing everyday activities like sitting, standing, walking, are all going to be signs that there might be something amiss. Sexual abuse, again, is fairly broad. It's both actual penetration as well as molestation or exploitation. Kids who are being sexually abused, you might see sexually transmitted diseases, UTIs, or oftentimes we'll see in young kids, more advanced sexual knowledge than what would be expected for a student of that age. Additionally, sexually acting out and being aggressive, especially in young children, is an indication that there might be sexual abuse to be concerned about. Neglect is one that I think is a little bit harder to really get a good handle on, and it's defined as failure to provide adequate supervision, medical care or attention, food, clothing, or shelter, or delay in such provision. The important thing here is that poverty is not the same as neglect, but signs that a student might be neglected include consistent hunger in the morning, poor hygiene, underweight, if they're frequently absent, or inappropriate clothing for the weather. Additionally, a parent not sending the student to school, for instance, if there's a special education dispute or something else going on, isn't in and of itself neglect. But a student who's only coming from time to time might be an indication that something else is going on and there might be a neglect situation.
I can add some more details to this. This is something that I think, because it's not a crisis, it develops over time. It's hard to know at what point. And I will say situations where I've seen DCFS be particularly helpful are, let's say, repeated incidents where a child has lice that's not being resolved, and really they need support in the home to get that cleared up. At times DCFS can support that. I've seen some more extreme medical issues that are not being cared for. It's always a hard call. At what point do we call DCFS? And usually you've tried to collaborate with the parent on those issues before, and it's just gotten to the point where it's truly neglectful, the medical neglect, and you need to make the call. Also hygiene. So if hygiene routines are not being followed through in the home, and there's not, but again, these are complicated because sometimes students, for example, have disabilities, and it's not just a neglect issue, but there's other impediments to following those routines. So they're not clear-cut, but especially on the neglect issues, sometimes it's a practical call of, we've tried everything else and we need another intervention, so let's try this. And we have seen that be helpful. Our next question, can DCFS investigators interview a child without anyone present? And the short answer is yes, they can. In our experience, they're usually amenable to having school personnel join because, and that is our recommendation, that unless you're told not to join, that whether the child is at a university campus, at a camp activity, or at a school district, and DCFS comes there because they're able to easily access the child without necessarily confronting the parents, that you do make the child available, but you do offer, and I would even say be a little bit pushy about trying to stay with the child for the interview. At that point, you are in the role essentially of the parent, the child's under your care at that point. So do everything you would as if, you were the guardian and someone was trying to interview the child. So we do recommend that. DCFS can insist that you not stay with the child and that they have that authority. At times, I ask them to put those type of things in writing because this is the type of situation where parents are going to be furious that you left my child alone with this stranger potentially. So sometimes directives that you're uncomfortable with or unsure, I just ask DCFS to put that in writing and actually direct you not to participate or direct you to do whatever it is they're asking. And so there's no dispute later that you were directed. It wasn't something that you initiated. We do have a question. Should we notify a parent if a DCFS investigator shows up at the school to interview the child? And
I think that's actually one of our later questions.
okay, so we're going to hold off. But, okay, question 5, I'll turn it back to Kendra.
Look at that. We'll have to contact parents when DCFS was present and interviewed their child. And there's not a law that requires you to contact the parent or prohibits you from contacting the parent. Generally, if the person accused of abuse is not the parent, then certainly we would let the parent know that this is going on and give them some information about something so important that's happening. It's obviously more complicated when the parent is the subject of the allegations. In that sense, there are limited circumstances where you may want to let the parent know that a report was made, that that the student was interviewed. If something like Jennifer was talking about where the parent is not providing adequate medical care and you've been going back and forth with the parent trying to encourage them to provide that, the parent probably will know that it was the school that made the report, and so being transparent may help support your relationship with that parent and may also help encourage the parent to provide that care and let them know how seriously you're taking that situation. In other situations, though, obviously there's a risk if you let the parent know that the student's been interviewed and they're the subject of an investigation, that the parent might take it out on the child, might try and persuade the child to recant their story, and so it creates some additional risks, and you may not want to immediately inform the parent. The DCFS investigator will often tell school personnel, we would like you not to, at this point, inform the parent, and so you can kind of collaborate with them a little bit about what the best practice would be in the specific situation.
To flesh that out, one situation I assisted with, a child reported that one of their parents had murdered someone the prior weekend, and it turned out that the child was the source of solving that murder and was interviewed, and obviously calling the parent to tell them that your child reported that you murdered someone puts the child in danger, So there is a certain component that becomes obvious with some of these. Obviously, in other situations, not nearly so obvious, but these are literally life and death situations at times. We did get one question. Can you provide the cites to the statutes you are referencing that create these obligations? We're largely speaking today about the Abused and Neglected Child Reporting Act, which is known as ANCRA, and it's in Illinois law at 325 ILCS 5, and it starts and goes on from there. There's also regulations implementing this law. This does apply to both. It has broad application, not only to public schools, but also to higher education entities that have responsibility for students that are minors or children that are minors in different various activities or under their care. So those are our clients that usually are under this obligation, and that is the main law we're speaking about today.
We do have another question about DCFS investigators being pushy and wanting to interview parties at school, and to what extent can school staff control the time, the day, location of the interviewers, or the interviews? And school is, like Jennifer said, often the easiest place for the investigator to come find the students without, having the parent right there. And so they do often come to school or to activities where they can find the student. As administrators, you can, it's going to depend case to case. If it's not an absolute emergency, and the student's in the middle of a final exam, maybe it can wait an hour until that exam is over and make sure that it's done in a way that is least disruptive possible. There may be some situations where it is really dire that they need to interrupt whatever's going on.
Great. With that, should a school release a child to a parent under DCFS investigation? So these situations can evolve rather quickly. You find out, DCFS notifies you that they're investigating something. You don't have all the information. The end of the day is rolling around, and you're concerned based on your limited but serious information about sending the child home. What are your options? At that point, I really see it as three options. You should follow DCFS guidance if you can get it. So sometimes you have to make a decision. Your DCFS case manager isn't calling you back right away. What do? There's always the local police as an option or a hospital as an option, depending on the situation. You as a school obviously cannot just hold the student indefinitely at the school or certainly overnight. So when the end of the day approaches and you're looking at what to do, it's either DCFS custody, local police custody, take the child to a hospital, or return the child to their parent or guardian, obviously.
Okay, question 7, should the school conduct an investigation of abuse or neglect? So first, if a child reports abuse, you should report it to DCFS. There's no need to do an investigation prior to reporting, and I think that's maybe part of what got the school in that news report in trouble, where they were questioning whether or not those reports were credible, and then ultimately didn't report. And there's no reason that you should be doing an investigation prior to reporting. If there's a reasonable cause to believe that abuse occurred, then you want to make that report right away. Once the report has been made, though, then you want to think about, what are the school's obligations? If the subject of the report is a parent or a third party, again, there's really no reason for the school to be involved in the investigation. DCFS has that obligation and responsibility. If, however, the subject of the report is a school employee, then you are going to have an obligation to determine what happened and make sure that other students are safe. At the end of the day, regardless of what DCFS determines, the school's investigation may or may not lead to discipline of the person accused of some sort of abuse. So, for instance, the report may end up being unfounded, but you might, through your own investigation, have enough that you think discipline is warranted, or vice versa. We have seen situations where DCFS will indicate a report for something that happened in school. For instance, a student accused a teacher of grabbing her by the arm in the hallway. The school did its own investigation, and even though DCFS found that it happened and it was abuse, the school did not think that it happened, and so did not discipline that employee. And so it can go either way. The school has their own obligation there. Separate from that, though, if there is an indicated finding, that will be reported to the regional superintendent and the state superintendent, who then can initiate license suspension or revocation actions. And so that, again, is its own separate process that might be initiated based on an indicated finding by DCFS.
Thank you. And with that, we do have a few more questions. I'll start with one question is, our experience has been that DCFS is overwhelmed and slow to respond. We have an agreement with local police that we call them when we call DCFS. What are our thoughts on this arrangement? I will say I work with a number of clients who have the same practice. Your legal obligation is to report to DCFS. So regardless of whether you think that call is going to be worthwhile, your first call should be to DCFS. However, I agree that our experience is that often local police are more effective as far as taking the child, doing a quick investigation, and just taking action where you express concerns. So, I think that's great if you can have that kind of relationship between local police, and hopefully it can be local police, DCFS, and the school all working together, certainly. So we did get a few more questions. Do you want to go ahead?
Talking about indicated findings, and an indicated finding means that there is evidence of abuse. It's not a terribly high standard, and the person who's the subject of that finding does have the opportunity to appeal that to a hearing where then the standard is more likely than not. It's greater than 50%. So the legal significance is that you do go on the registry of people who have been found to have committed abuse or neglect, and that's for at least 5 years. It depends on the nature of the offense. But then any sort of criminal prosecution would be separate.
So we have another question. What is, or who among school staff needs to know when a DCFS report is made? And that's a good question. For that, I would rely on the standard in the Illinois School Student Records Act or the FERPA. And either way, it's when there's an administrative or educational need to know. So, for example, if one teacher reports another teacher because you observe something that you believe to be abuse of a student, sharing that obviously with administration so that they can separately investigate and take action is someone who administratively needs to know. There is no confidentiality bar from sharing that information with others within the school. With that, I think there's maybe one other question we can tackle here. What is the best way to document when the DCFS report is made for a student? Where should that documentation be kept? So
when you make a report on the phone, on the hotline, and I think actually we've got that information on the next slide here, you do need to follow up with a written report, and there's a particular form that DCFS will direct you to. And so there will be written documentation that you provide to DCFS that restates probably what you have already said on the phone on the hotline.
And that is something that we do recommend you keep yourself. So the school could keep that, but the individual who observed the abuse or neglect and had the obligation to call should also keep that for their own peace of mind. We have had situations where there becomes a question later on whether a call was made, and it's just, I would feel better if I was a school administrator having that documentation myself and not relying that it was well kept elsewhere. This is a different situation from other kinds of obligations on educational institutions because it's not a law that the entity has to follow. This is specific to individuals who work at educational institutions, and the penalties are on individuals. I mean, these, as we saw in the initial clip. So it is a difference where, yes, it's good to help and support individual staff members in making their reports or keeping documentation, but the obligation is individual to personnel. So, I think it's a belt and suspenders situation for where everyone would want to keep their own documentation as well.
Yeah, and that brings up another, question we often get is if a child makes a report to, the teacher's aide or a teacher or a counselor, does that person need to talk with an administrator first, or can they talk with an administrator first before making a report? They absolutely do not have to. They can if they would like to. The administration should not discourage someone from making a report or take that responsibility to make the report in their stead. The person who has the most knowledge or who has that direct knowledge should be making the report to DCFS.
So with that, thank you for all your great questions today and for joining us for the monthly webinar. I do want to encourage everyone to save the date. Our next webinar will be on August 21st, again at 10 o'clock, and focus on an Illinois legislative update. So what educators need to know about new Illinois law this year. So thank you and see you then.